The next argument scheduled for this morning is State of Ohio versus Andrew Fazenbaker. It's case number 29108. State of Ohio has waived oral argument, so we will only hear from Attorney Armstrong on behalf of Mr. Fazenbaker, the appellant. You will have 15 minutes for your argument, and we've read the briefs and are ready to proceed if you are, sir.
Yes, Your Honor. Thank you. May it please the Court. My name is James Armstrong, and I represent Andrew Fazenbaker. Your Honor, the main issue in this case is what is an unoccupied structure. In my brief, I cite a very well-written decision from the Ohio Supreme Court. It was unanimous. I say well-written not in terms of its decision regarding the VW bus, but because of the legal analysis they do to try to determine what is an unoccupied structure, since, as I'm sure we all know, it's not defined in the statute on the unoccupied structure is. And I admire the Supreme Court for starting at the basics of our judicial system, with the common law, what was burglary, what was his intent. In this case, we have a 34-foot trailer, which I would concede, if it was parked anywhere else, may be a non-occupied structure at the time. But the facts of this case do not correspond to that. The facts of this case correspond to a trailer that had been stored for an extended period of time at a place called storage area. It was there, which the owner went back about a year and a half later, after parking it there and storing it there, determined that somebody had broken in and the TV was missing and some other things were missing. My dispute with the trial court in this matter is they did not follow the analysis of the Supreme Court in Carroll.
Carroll said an unoccupied structure is anything that could fit under the definition of occupied structure, basically. That's not occupied. Am I correct?
I believe you are, Your Honor, but the interesting part about that is it's very fact-centered. What I appreciate the Supreme Court in Carroll is they gave the template to look at all the other cases that come up, because it's so fact-specific what is an unoccupied structure. I point out in my brief, the state mentions it too, but I can see the point that if this was a trailer parked in somebody's driveway, because I think the state points out Pierce, which is the 10th District case, and is completely irrelevant. That's not the point.
So you're saying the location of the structure is important?
Absolutely.
To that determination?
Absolutely, because under the trial court's ruling, essentially, if somebody had a couch in a storage area, you could argue that they could go and spend the night in the storage area if they got mad at their spouse.
Well,
that's
I
not
think
really
they're saying if that storage area had a couch, a sofa, a TV, an entertainment center, cabinetry, a bathroom, a kitchen, a bedroom, yeah, you might be able to live in it. As opposed to just a couch where you may be storing.
And Your Honor, if this was at Jellystone Park or a KOA campground, I would entirely agree with the court. It was in a storage area. What is the purpose of a storage area? To, quote, store things. If you're storing something, by definition, it's something you're not planning on using. That's why this is so important, because it's where the location of the trailer was. When I read the state's brief and they kind of reiterated what I said about, with regard to Pierce, that it was in the backyard, I was reminded of my aunt and uncle in the Philadelphia area when I used to go visit them. I was all excited. They had a camper, and I got to stay at the camper with my cousins while the adults stayed in the house. I was a little older when I realized actually the adults did that on purpose, but that's a kind of a different situation where you have a place where it's very obvious that somebody on a daily or hourly basis could be using in their case, a camper. Here we have a trailer. That's not the situation here.
What about a trailer that's like a new trailer or a used trailer that's being sold on a lot? Like all these, a camper city or whatever. I know, that's why I asked you, because I don't know the answer.
I would actually argue in that situation, it would not be titled, it would not be owned, and there would be no one that would be legally allowed to be spending the night in that trailer, except unless maybe the owner of the camper trouble with his wife and or spouse and decided that's where they're going to spend the night. But that's, again, where this case is so fact-specific, and why I go back to the Carroll analysis, and it's the analysis that I hopefully successfully focused on my brief on. If you follow the analysis of the Supreme Court in their unanimous case in Carroll, you're then stuck with a situation where you have a trailer here that clearly was not in a condition to be spent the night on. First of all, it's in a storage zone, right? I don't remember this in the transcript, forgive me, but those storage areas have certain times that you're even allowed to be there. You also have a situation where it was covered, where it was winterized. The owner admitted that they went out there to get it ready to be used, so there was also an admission during the trial that it wasn't in condition to be used. And that's why that fact is so important to this case, because if a trailer covered, winterized, and in a storage area away from the owner's ability to use at their whim, is considered an unoccupied structure under the burglary statute, then there's really no definition of what would not be an unoccupied structure if you carry the theory far enough along. That's the reason I made the reference to the storage center. If you have a storage unit, you have a couch and whatnot, and you go there and took a nap, that's a theory that could possibly happen. Is that really what the intent was? And I think that's, again, why I pointed to the Carroll case, where they focus on the committee resuscitation of what took place when they went through this. They focused on the common law purpose of burglary.
So the state is saying that you're not really arguing that he didn't unlawfully enter and steal the items. It's just a matter of what the charge was, basically.
Your Honor, considering the limited amount of pages you have, you focus on the best argument. The best argument in this case is it an unoccupied structure, which indeed is an element to the case. The state has to prove every single element. That's the weakest element that I found, as opposed to trying to argue, some DNA from the cigarette argument.
I understand. The reason I'm asking this because I know you indicated that he could have been charged with criminal trespass, that basically this was the wrong charge, but I'm thinking he probably could have been charged with grand theft as well. I mean, he took several items.
Well, Your Honor, there's no evidence that he took the items.
I understand, but let's say hypothetically he did.
Well, hypothetically, could have, would have, but then he would have been denied due process if they decided to, charge him, try him for grand theft and was not indicted for that.
Sure, I understand that. I understand that. I'm just trying to figure out if, like you said, if that wasn't the meaning of the statute, if they're turning everything into an unoccupied structure or an occupied structure, basically any structure is either occupied or unoccupied, according to maybe your argument, then I was just trying to get it. When somebody breaks into something that may not be an occupied and unoccupied structure, what is the offense then? Has to be some offense.
Well, Your Honor, assuming that all be true, you're looking at a criminal trespass. No different than if I won't use Mr. Fazenbaker, if I went into a storage unit after hours and went into some storage unit, whether I took anything or not, it could be breaking in or part of breaking in, but it could be criminal trespass.
But he took something from the storage unit.
And then if and then it goes on from there with regard to the facts. Here, the real issue is the trailer itself, and I don't think that's in dispute. Even with the state's argument, the state pretty much argues that it's an unoccupied structure under the statute. They don't really go into the analysis that I did with regard to Carroll, nor do they review it. And I found it interesting that when looking at the trial court's rationale for why this was an unoccupied structure, how closely it mirrored the rationale of the appellate court that the unanimous Supreme Court reversed. Basically arguing the same thing, that any product construction capable of being occupied by at least one person, it'd be such a broad interpretation that anything would be. And the purpose of of the argument here is that that's kind of what the trial court did in this case. It had such a broad interpretation of an unoccupied structure. It was under the theory that, well, if possibly somebody at some time in the future could use it as a place to live, then it is an unoccupied structure. And that, under the analysis in Carroll and under the statute itself, is such a broad definition that you essentially don't have a definition.
But in Carroll, wasn't that involved a tent camper?
It involved a VW bus that could be transformed into a trailer. And that's why they focused on the fact that it could have been in a campground ready for camping, an unoccupied structure, but when the camper was down, it wouldn't be an unoccupied structure.
Okay, that's what I was thinking of then. It was flat.
Correct.
Did they make that distinction? It was flat, it was folded up for storage. It wasn't an occupied structure as opposed to being not flat.
It was collapsed for storage, just as the trailer in this case was covered and winterized for storage in a storage area. That's the reason why that case is so relevant to the facts of this case. Because under both scenarios, the vehicle that could be an unoccupied structure, given certain different facts, was in a position of being in
Isn't
storage.
the distinction though between Carroll and Pierce, the fact that there were all these other things in these vehicles, the beds, the refrigerators, the stoves, the cabinetry, the bedrooms?
With respect, Your Honor, I don't agree with that. The difference in Pierce, as opposed to Carroll, and certainly in this case, was in Pierce, the trailer or camper was parked in the backyard of the residence of the people who owned it. And in my own brief, I argue that if this trailer was in a different location, at a campground, in the person's driveway even, then you can legitimately argue that it was an unoccupied structure pursuant to the burglary statute.
Of course, occupied structure, the definition doesn't mention anything about location. It says when maintained as a permanent or temporary dwelling, even if temporarily unoccupied. You know, thing could be an item could be in storage and be temporarily unoccupied.
Which is why the analysis of Carroll is so very important, because that's where they focus on, if you use that definition, you have such a broad interpretation of that statute that it fits under anything. That's again why the Carroll case is so very important. If you go through the process of what Carroll does to try to eliminate that opportunity to where anything under the sun where somebody can spend the night could be an unoccupied structure.
So your argument is that the lower court misapplied Carroll?
Absolutely. And then that decision in and of itself affected every other decision the trial court made. That affected the conduct of the trial. That affected when the counsel for the defendant made the motion under Criminal Rule 29 to dismiss the case. It should have been granted based on the fact that we were not talking on an unoccupied structure pursuant to the statute. It affected the charge to the jury by not being able to define that and almost giving the jury the assumption that that element was conceded when it was not.
You would agree that this camper in this case would be an occupied structure if the victims were present in it, using it. But is the reverse also true then? It's an unoccupied structure when they're not present and using it? Then you're going to say.
But you also have, you also have to have taking an account of the normal use of that vehicle. If the normal use of the vehicle, actually I think this was pulled, if I remember the transcript correctly, but if the normal use of that vehicle is being utilized, then clearly then it would be an occupied structure.
They were staying there cleaning it, and they had permission to stay for 3 days to get it cleaned up, get ready for camping season. You know, they had permission from the owner of the storage unit. Yeah, come on, you can stay a couple days there, get ready for camping. Temporarily being used.
Well, Your Honor, what I've noted by your question is there's almost a concession that it was not ready to be used. It was not capable of being used as.
That's what you're arguing.
So that's the first part that I caught from your question was, it's almost a concession that yes, this trailer clearly wasn't in a position to be utilized as it's intended. With regard to the storage unit in the question as well, Your Honor, is that you have to create so many assumptions to get to the point where it could be an occupied structure, which then leads us back to the Carroll rationale of if we do that, anything under any possible structure in theory could be used as an occupied structure at some time, depending on circumstances.
And with that, you are out of time. Thank you very much for your arguments this morning. Court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to counsel on the day it is released. And as you know, Attorney Armstrong, the opinions are also posted on the Supreme Court of Ohio's website. We appreciate your argument today.
Thank you very much, Your Honor. I need to improve my